Lawyers. Selectors, what is the strangest or oddest law that's won a case for you? I got a pro bono client's removal by USCIS cancelled. He had a low-level drug possession conviction from the early 1980s. During that brief period, the active ingredient of Imodium was illegal under state law, but not federal law. So I successfully argued that they couldn't prove it wasn't a conviction for possession of a substance that was federally legal at the time, and as such was not subject to removal. The argument worked and my guy went back to his business and his family. I had a case where a guy was charged for running a red light. The thing is, he had been sitting at the lights for 5 minutes and it hadn't changed. The wording of the specific section under which he was charged related to stop signs and traffic lights and referred to them as traffic regulation devices. I successfully argued that as the traffic light wasn't changing, it wasn't regulating traffic and he got off. I couldn't believe it when the judge ruled in my favor, neither could the police prosecutor. A guy got drunk and decided to ride his horse through town. This was a small town in North Carolina. Well, he would stop at each intersection and fire his pistol in the air like some Wild West cowboy. Anyway, the guy was charged with a DUI and discharging a firearm within city limits, which was a felony. So as one would soon find, it is not just mandatory, but a law that you must fire your firearm into the air at an intersection when coming through town on your horse. An old blue law that never got erased. He still got the DUI and his horse got impounded, but the dumbfounded judge dropped the other charges. Over 10 years ago, I had been at fault for rear-ending someone else. I had no insurance and my license had expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of a fix-it ticket about my suspended license. I sorted that out in the days after and nothing came of that ticket. The cop had mentioned that he had to write the insurance ticket, but to take it into court and get it lower. I was desperate to try and get my $800 insurance ticket lowered because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me and said, "I would like to use Mr. South Seattle's case as an example to the gallery." I almost died. He went on, "This is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. South Seattle accountable to this." My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure that cop deliberately didn't write the date on that ticket. Thanks, officer. I had a very similar thing happen. I rear-ended someone, but it turned out the person I hit had a warrant for their arrest. While other cops were taking care of that, another came over to me and gave me a ticket. While he did that, he flipped it over and showed me the instructions to fight it in court. Well, I followed those instructions, and when I got to court, the officer had a family emergency and wasn't able to go, which threw out the case and also my ticket. Thank you to whoever that was. In 2016, prison inmate John Motti was charged with escaping from the prison in which he was incarcerated, which is a crime in Ohio. The prosecution, however, failed to establish that the Hocking Correctional Facility and therefore the crime was located within the court's jurisdiction of Hocking County, as all witnesses potentially able to offer testimony on the prison's location had gone home for the day, and, incredibly, no one remaining could provide references allowing the court to take judicial notice of the prison's location. The charges against Motti were dismissed, and he was allowed to return to prison to serve his sentence, but at least without additional charges concerning his alleged escape. Had a case where my defendant opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond executed by the individual defendant or a corporate officer. When my opponent's assistant electronically filed the appeal, she attached a PDF of the bond without the corporate signature. There's no question in my mind they had the bond with the requisite signature, and simply attached the wrong version of the document to the filing. Wish I could say there was a huge court fight over this. and I got to slam my opponent. But that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button, and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client, but I doubt it. My brother is a lawyer. He got a DUI charge dropped for a client. Guy gets pulled over. Cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car asks the officer if it's okay for him to reposition his vehicle to move it further away from the road, because he feels uncomfortable being that close. The cop obliges. Apparently the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. This happened with a guy I know on his boat. He is a huge 65-foot Viking and the cops couldn't dock it, so they asked him to. His lawyer shows up and says the cops made my client dock his own boat after they decided to take him in for DWI. Sober water patrol couldn't dock the boat, but an impaired person can. Case dismissed. I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside drawer, walked into his living room, and confronted a figure in the dark. The person didn't identify himself, but moved towards my client, who fired a single shot that went through the person's shoulder. Turned out it was my client's stepson who had snuck out, been drinking underage, and stumbled home. The problem with the situation was that my client was a convicted felon several times over. That meant that while the shooting itself was legally defensible, his possession of the firearm was not. We looked into the history of the gun itself, as our client had indicated it had belonged to his grandfather, who had served in the US Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the very first batch of firearms distributed from Colt to the US Army at the Augusta Armory. Florida Statute 791 creates an exemption of firearm-related laws, including the prohibition for felons to possess a firearm if the firearm in question was an antique, meaning it was manufactured prior to 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potential mandatory prison sentence. That's some beautiful lawyering right there. But also, your client probably needed a divorce lawyer after this. Early in my career, I had a fairly minor case in which my client's neighbor cut down a bunch of shrubs and small trees bordering their properties because they blocked his view. This really irritated my client, as he wanted his privacy. Now, the monetary damages were actually not that much, and this was looking like a case that really couldn't be economically litigated for what the client could afford. However, in researching the issue, I found a rather obscure law that provides for attorney's fees to a winning plaintiff when a defendant has willfully damaged the border foliage of a ranch or farm. In looking up the definition of these terms, I realized that my client's property actually qualified for the statute, as he used his land for growing a variety of produce for market. Once attorney's fees were on the table, the other side quickly caved and wrote a big check to cover the damages. Not a lawyer, but I got a charge dropped because of the cop's bad handwriting. I got a ticket on a Monday night for speeding, and was given the court date of like 2 months from then. About a week and a half later, I get a letter in the mail that I'm being charged with a failure to appear for court. I'm in court 2 days later for that, and tell the judge not guilty on the FTA, and no contest on the speeding. After asking him to just look at the date on the ticket and my supposed original court date, he sets them down and goes, "You have a point there. Not guilty on the failure to appear. And how do you plead for the speeding charge?" I replied, "No contest. I was speeding, Your Honor." He looks at the ticket, sees that the cop had initially put 10 over and in a notes put my actual speed like 20 to 30 over, and goes, "Yes, it certainly looks that way." Not me personally, but this was a case we covered in my first year of law school. Essentially, in 1912, the Appellate Division held that women could not be lawyers in South Africa, as the relevant statute referred to person, and women were less than a person. Incorporated Law Society v. Wilkie 14 years later, Activist-minded judges applied this finding to a past law case during apartheid. To sum it up, they reasoned that because women were not people, and only black people were required to carry a pass, black women were not required to and could not be arrested or penalized for not having a pass. Rex v. Dedity. My mom was getting sued by a debt collection company that was well known for suing people as a means of threatening them. I had some time, and I looked up the laws on debt collection. Where we lived at the time, you had the right to demand in writing that they provide evidence that they actually hold the debt, and they had a certain amount of time to respond under the law, or they forfeit any right they had to collect said debt. I sent them a certified letter. We never heard back from them. When we went to court, I submitted the receipt for the certified letter and said they had failed to provide the proof within the legal time frame and cited the law. Case dismissed with prejudice. The lawyer for their side didn't even care. I had one where a client was contesting a will. Halfway through the case, the other side argued that my client was set to inherit less without the will if we won than she would with it if we lost, and argued she lacked standing to attack the will. The decedent had a very old will that benefited our client's deceased mother, but that will had been revoked. We found a very old doctrine in a footnote to something else entirely and argued to the judge that the law assumes you'd rather die with an old, revoked will than with none at all. Therefore, we argued he should look back to the prior will. Since our client would inherit her mother's bequest under the prior will, he held our client had standing to bring the will contest. We ended up settling the case shortly thereafter. Happened to me, and I was a teenager. My friends and I bought some beer and then went to a high school football game the first week of my senior year. We obviously got caught and all 6 of us got tickets for underage possession of alcohol. I was the DD and had been driving my dad's Suburban with our very unique last name on the license plate, so it was really easy to figure out whose car it was. Went to court a few months later. The Ada presents her case. Cops testify. They even brought the alcohol in as evidence. Right after she rested her case, my attorney steps up and asks the judge to dismiss the case. We are all very confused. The judge looks at the Ada and just kind of shakes her head and agrees. My attorney explained later that she forgot to prove that we were under 21, so there wasn't a case anymore. I've never been so glad for a technicality in my life. Here in Texas, if you get in an accident on a public road with someone that you are related to by a certain degree of closeness, such as a sibling as the driver, you can't sue them unless the crash was intentional or essentially reckless. It is a decades-old statute that doesn't get trotted out terribly much at all, but I coincidentally stumbled on it, and it managed to be the saving grace for a client who was being sued by his in-laws for a crash while taking them to the airport. Yanel. But I won my case by exploiting a legal technicality in my jurisdiction. My case needed to be tried at a certain court, but they tried me in another court, and by trying me in the wrong court, basically broke the law. I made them aware of this, and had my case dismissed. Many years ago I actually saw this in the newspaper, but I'm now thinking it's an urban legend because I can't find anything online about it. Apparently a 20-year-old man was cited for underage drinking in Michigan. He argued that since it says in the Michigan state constitution that life begins at conception and that since he was over 20 years and 9 months old he was obviously old enough to drink. And he won. True or not, I can't say. Yanel, I was the defendant. I got pulled over with a girl and we both got searched as well as the car. There was some weed and a bowl on my car. They threw that in individual bags then, in a large evidence envelope. They found a small bag of cocaine on her and tossed it in the large envelope. Well, they lost her cocaine. Since there were only 2 pieces of evidence and not 3, we got off free of any fines or charges. We had 3. That's only 2. Not our stuff. I used to haul produce for my neighbors who had a small vegetable farm to the farmer's market and then sell it in the mornings and come back in the afternoons. On Memorial Day weekend coming back from the market they had a DUI checkpoint in the afternoon. I didn't have my driver's license with me because I had forgotten my wallet that morning when I left, so they wrote me a ticket for not having my license. That they wrote the ticket to the owner of the truck, not to me. When I got to court, I was standing in line next to the cop, and right before we walked up to the judge I whisper, "I'm gonna get out of this one," and he just looked confused. I then explained to the judge what had happened and that I was obviously not the 67-year-old truck owner the ticket had been written for. The judge looked at the cop with utter disdain and dismissed it. I wasn't the lawyer, but a bailiff at the time. This wasn't strange so much as funny in a way. So an officer pulled over a man for obviously driving while intoxicated, or so it seemed, swerving a bit slower than expected for the flow of traffic, which yes, that can get you a ticket, and blowing through a stop sign. Soon as the officer pulled the guy over, the man stepped out of the vehicle and took a big-ass swig from a bottle of whiskey. Officer arrested him with DUI, and dude did blow well over the legal limit. Fast forward to the trial. The guy's lawyer argued that while his client may have been impaired driving, the fact remains that since he drank a big swig of alcohol as soon as he was stopped and stepped out of the vehicle, the officer couldn't be certain if that was what pushed him over the legal limit or not. The lawyer countered that the officer couldn't then reasonably charge him with DUI, as it was entirely possible that he was fine before that last big gulp. Long story short, the judge agreed and had to throw out the DUI charge, though he didn't want to, as he reasoned that while the defendant's reasoning was sound in the law, by the same token he feared it might encourage abuse. Whatever the case, the guy got off on the DUI charge. I later heard that this may not have been the first time the guy has tried that stunt. My friend got off his DUI case for smoking weed with his buddy because the officer mixed up their last names. Virginia divorce. Female spouse was cheating on well-off male spouse. Man found out, started divorce proceeding, and women found out she would get no spousal support. She did, however, find out about a concept called condonation, which means if you sleep with someone after knowing they committed adultery, you have forgiven them and can get spousal support. Well, one night of text messages and a few photos confirmed it, and client received a lucrative spousal settlement based on the new information. This one actually made me laugh. My father was hired by a guy who had killed a possum and about 8 babies by running them over with a car. Was charged with 9 counts of animal cruelty. Each one had something like a year in jail and a significant fine. So, anyways, why dad files a motion to dismiss because, per state law at the time, possum are not technically animals by the law, but vermin. The state's organization responsible for vermin, I think Natural Resources, produces pamphlets on how to kill possums by drowning. He argues that the client in fact did less harm to the possums than the state itself directs the client to do. Wins on a pre-trial motion. Makes the national news. I have a good friend who defended a hunter who shot a deer and then proceeded to fuck the bullet hole. The game warden happened to be in the area and caught him in the act. Went to court, and the law in that particular state says that the crime of bestiality has to be in a predetermined orifice. My friend explains this law to the judge and the guy is acquitted on the spot. Not me, but attorney at a firm I used to work at. Officer pulled over driver and hit him with a DUI. At trial, attorney asked officer the reasonable suspicion basis for pulling the driver over. The officer said it was because the driver didn't have front license plates. Driver was from out of state and driving a car registered in a state that does not require front plates. Attorney successfully argued that not having front plates is not reasonable suspicion basis to justify a traffic stop since many states do not require front license plates. Thanks for watching. Share your stories in the comments.